So good morning, everyone, and welcome to our session on privacy, how to outsource work while keeping you and your customers safe. My name is Carrie Lee Auger. I'm the Skills Development Manager here at Women's Enterprise Center. My role is focused on providing education, training, and resources like this webinar to support women entrepreneurs through their entrepreneurial journey to empower them to build their businesses. So if there's a topic that you would like us to consider or a speaker you can recommend, please be sure to watch in the follow-up email and provide that feedback in the survey, the brief survey that we send out to you as well. So Women's Enterprise Center, for those of you just joining us potentially for the first time, we're a nonprofit organization devoted to helping BC women start, lead, and grow their own business. Our full range of services includes business loans up to $150,000 with access to an additional $100,000 through a partnership with BDC. We also provide business advice, skills training, mentoring, resources, and a supportive community to help women entrepreneurs realize their business potential. We do it right now remotely, but from 3 offices located in Kelowna, Vancouver, and Victoria. And our passion is to empower women entrepreneurs to their business success. And all this is possible by the funding we receive from Western Economic Diversification as part of the Women's Entrepreneurship Initiative, including similar organizations in Alberta, Saskatchewan, and Manitoba. And during COVID, we have a dedicated page, wec.ca/COVID-19, where you can find access to a lot of recordings of sessions similar to this, information on our business advisory services, mentor program, online training, and then updates as they become available to any of the supports offered by the government and other organizations. So it's a great page to have bookmarked on your desktop for quick reference. So today, quickly, for those of you on Zoom that want to participate as well, we've got the chat and Q&A that we're going to be monitoring today. I encourage you, as your questions come up, or if you have them already, type those in there, as Katherine and I will be reviewing those as we go through the presentation today. And we want to make sure we answer as many of them as you can. And of course, as Katherine goes through her content today, she might answer some of those for you. So we'll take a look at that as we go through, but I encourage you, as those questions come up, as you're thinking about them, pop them in there and we'll take a look at that as we move through today. So on today's session, I'm pleased to have with us Katherine McNeill. She's an associate at Borden Ladner Gervais BLG in Vancouver. And today she's going to talk to us about outsourcing, which is a great strategy for us to tackle projects, functions, take some of the work off our plate as well, get some business supports. But we want to make sure that we comply with the privacy laws when we're doing that. So Katherine today is going to give us a brief summary of some of the Canadian privacy law principles, our legal obligations as business owners for maintaining privacy when we outsource work to third-party providers, and some really practical recommendations for outsourcing arrangements. So what does that look like for you? So Katherine maintains a corporate and commercial law practice with a particular focus on privacy, cybersecurity, and other information technology law-related issues. She has experience advising clients in connection with privacy and data protection law compliance, outsourcing arrangements and other commercial agreements, mergers and acquisitions, the CASL or anti-spam legislation compliance that we need, and advertising, marketing, and sponsorship agreements. So Katherine, welcome. Thank you so much for joining us today. And I will hand it off to you if you would like to do the screen share and just say a brief hello before we get started today.
Sure, thank you, Carolee. I'm just gonna share my screen now and get my presentation up here.
Perfect. Hopefully it works as well as it did on our test, not like my internet crashing right before we started.
looks to be working to me.
Yeah, great.
Hi everyone, thank you for tuning in. Like Carrie Lee mentioned, I am a 4th-year associate in the corporate commercial group at BLG. A huge component of my practice is privacy law, which comes up in a lot of ways. It comes up in almost every context that we're advising our clients on, but a big one where it comes up a lot is outsourcing. And Outsourcing is a critical function for almost every single business, every single organization out there. The ability to outsource business functions, platforms, gives you access to other solutions and other services that you cannot do internally or in-house. And for many businesses, particularly smaller ones, the ability to outsource is absolutely critical to the ability to carry on your business. A lot of organizations just don't have the resources or don't have the specialization necessary to be able to carry on their business without outsourcing at least some business functions to third-party service providers. This presentation will talk about the privacy risks inherent to outsourcing to third-party service providers and talk about your obligations with respect to Canadian privacy legislation. Just by way of a brief overview, outsourcing to third-party service providers involves a lot of transfers of personal information, which is not prohibited under Canadian privacy laws, but there are a lot of obligations in connection with transferring personal information over to that third-party service provider. And there are a couple other issues that we'll touch on today, the two most important of which are, first is the transfer of personal information across jurisdictional borders. In Canada, there's a bit of a distinction between transferring to a third-party service provider in your jurisdictions, which usually when we mean jurisdiction, we're talking about your own province. So if you transfer to a third-party service provider who's located in another province or located in another country, that gives rise to some additional concerns and risks that we'll talk about. And the second issue is outsourcing using cloud computing, which is a third-party service provider that's allowing you to store your data up in the cloud in some way. And there are a couple different models for using that. But again, using a cloud service provider gives rise to some additional risks and concerns that we'll talk about. And by the end of this, we will talk about some practical tips and tricks that you can use to outsource your business functions to a third-party service provider, with the underlying goal that you're protecting yourself and you're protecting your customers. So we'll start out, the presentation will talk about three things like Carrie Lee mentioned. The first part of the presentation will talk about a brief summary of relevant Canadian privacy law principles and give you a brief background of privacy law in Canada, just so you feel a little bit coherent about what we're talking about. And then we'll talk about organizational privacy law obligations under those privacy laws that we just talked about. And then lastly, we'll talk about the practical recommendations for entering into and continuing maintaining outsourcing arrangements. So the first part, a brief summary of relevant Canadian privacy law principles. The privacy law framework in Canada is a little bit complicated. At the federal level, you have what we call the Personal Information Protection and Electronic Documents Act. We call it PIPEDA for short because that's a little bit of a mouthful. And then we'll talk about, in addition to the federal PIPEDA, you also have provincial legislation in 4 provinces. And those provinces are BC, Alberta, or sorry, 3 provinces, BC, Alberta, and Quebec. And wherever you have provincial legislation, the federal legislation does not apply in that province. So if you are located entirely in BC, then the federal legislation does not apply to you, but the federal legislation does apply to every province that does not have its own Personal Information Protection Act. So again, you have the federal on the one side, and then you have the 3 provincial acts as well, and those are BC, Alberta, and Quebec. So at the federal level, just by way of a brief overview of what the federal PIPEDA does, it regulates the collection, use, and disclosure of personal information in the course of commercial activities by private sector organizations. And again, it regulates this in all provinces that do not have provincial privacy legislation, which is everywhere except BC, Alberta, and Quebec. And just a couple notes, you'll note that this is for private sector organizations. In this presentation, we are exclusively talking about private sector organizations, and there's some other legislation that applies to governmental bodies. We're not going to touch on that today, but just something to be aware of, that everything we're talking about today is for private sector. A few notes about PIPEDA: it generally excludes not-for-profit and charitable organizations and also political parties and associations, unless there are some nuances, but unless those organizations are engaging in commercial activities. But mostly PIPEDA applies private sector organization engaging in commercial activities. PIPEDA also applies to the collection, use, and disclosure of personal information by what we call federal works, undertakings, or businesses. And those are things that are designated by law, would be as a federal work, undertaking, or business. And examples of those are banks, airlines, railways, telecommunications companies. And those, PIPEDA applies to those organizations no matter where they are located. And lastly, PIPEDA also regulates the collection, use, and disclosure of personal information across provincial borders. So I see a question is just coming in that I'm just about to answer. Great question, Jacqueline. If you are located in BC, you're entirely located in BC, but you're transferring personal information across the provincial border. Let's say you're transferring personal information over to Alberta. PIPEDA then kicks in, and it applies to that transfer of personal information across the borders. However, the BC legislation would apply to all of your other activities in BC. And then if you have multiple organizational offices, let's say you have one office in BC and then you have one office in Alberta, the privacy laws work together in that multiple privacy laws could apply to you at the same time. So your operations in BC, the BC PIPA would apply to those, but as soon as you transfer personal information over to another province, PIPEDA would kick in, and then let's say your other operations in Alberta, then the Alberta PIPA would apply to those operations in Alberta. So keep in mind, it's important to know all of your privacy obligations under all of these different statutes, because a lot of them can apply to different activities that you're doing. Happily, not to make you panic too much, but happily, the privacy commissioners, the BC, Alberta, and federal and Quebec have all deemed each legislation to be what they call substantially similar, which means that if you're complying with the BC provincial legislation, you are almost certainly in compliance with PIPEDA, subject to a few very limited exceptions, but generally the obligations are very, very similar. And then one last note about the PIPEDA: it is administered by the Office of the Privacy Commissioner of Canada. And then I mentioned there are 3 provincial acts where there are 3 provinces where there are provincial privacy legislation. The first in BC, which is the most relevant to you, is the Personal Information Protection Act. In Alberta, they've very handily named it the exact same thing. Again, Personal Information Protection Act of Alberta. And then over in Quebec, you have the Act respecting the protection of personal information in the private sector. Each of these acts are administered by their provincial privacy commissioners. In BC, it's the Office of the Information Privacy Commissioner of BC, and then very similar in Alberta and Quebec. And then just like I mentioned before, all the privacy commissioners have gotten together and declared that the provincial legislation is substantially similar to the federal legislation. So compliance under one is generally means your compliance under the others, subject to a few very limited exceptions. We're not going to talk about them today because they're not relevant to outsourcing, but generally they're all very, very similar. And then there are some other pieces of legislation just to be aware of. The first is that there can be information-specific legislation. The most common example that we see of that is personal health information. In BC, to note that there's no distinction in BC between general personal information and personal health information, but some other provinces do make that distinction and have enacted specific legislation about personal health information. And the idea being personal health information in quite a few instances can be quite a bit more sensitive than, let's say, your name and your email address, thereby requiring a little bit more stringent regulation. But in BC, you don't need to worry about that. Personal health information is just personal information. And then you have industry-specific legislation, and some examples of that would be financial institutions. If you're a bank, you're subject to some additional regulatory guidance and some additional legislative obligations, and the same thing with securities market participants. So if you are a publicly traded company. And then a couple other international privacy legislations to keep in mind. You may have heard of the European Union General Data Protection Regulation, the GDPR. The GDPR is very, very stringent and has caused a lot of Canadian organizations a lot of grief. It came into force a couple years ago. Fairly different from Canadian privacy legislation. We're not going to touch on that. That's definitely beyond the scope of this presentation. But if you do a lot of business in the European Union or the European Economic Area, maybe just keep it in the back of your mind that GDPR could apply. And that might be something to speak to a lawyer about now, or maybe when you scale up operations, fines can be quite significant. So it's a good thing to keep in mind. And then another one that's a good thing to keep in mind is the California Consumer Privacy Act, what we call the CCPA. It was recently enacted in California, also has some fairly stringent obligations under it that in some ways differ from Canadian privacy laws. We won't touch on it here because it's beyond the scope, but if you do a lot of business in California, you advertise a lot in California, have a lot of California clients, that might be something that would be good to raise with a lawyer now or when you scale up operations, just to make sure that you are not offside those obligations. And I raise one final thing about privacy legislation. There is a lot of talk right now about amendments to privacy legislation, both at the federal level and a lot at the provincial level. A lot of this is in flux and there's been a lot of call for reform. So everything we talk about today is accurate as of today's presentation, but just keep it in mind that we're expecting some changes to come down the pipe, and that might change your privacy obligations for your business. You might start reading about some of this stuff in the news, depending on where you get your news from. But I think this is something that's really critical to keep in mind, because we don't know exactly what those changes are going to be, but we're expecting some fairly significant changes. At the Canadian federal level, in May 2019, the federal government released what they called the Digital Charter. And the Digital Charter essentially criticized the existing PIPEDA and called for fairly significant reform of privacy legislation. One of the most significant pieces of which relates to enforcement mechanisms. And the Digital Charter is contemplating an overhaul of the enforcement under PIPEDA. And then at the provincial level, you have, there's same kind of thing going on. The Quebec provincial government recently introduced Bill 64, which is an act to modernize legislative provisions as regards the protection of personal information. And this, again, contemplates some fairly significant changes to Quebec's privacy sector legislation. And as well, public sector doesn't really concern us. And then in the BC provincial government, very recently, this past month, actually in August, they concluded a consultation on the reform of the BC PIPA, and they're expecting to release a report of the results of their consultation in early 2021. Again, we don't know exactly what's going to be in that report. I think it'll be really interesting to see what kinds of reform they're contemplating at the provincial level. But we're expecting the reform at the provincial level to probably be fairly similar to the reform at the federal level, to make everything, given their past preference to make provincial legislation very similar to federal legislation. And lastly, the Ontario provincial government. You might recall that Ontario doesn't currently have any specific personal information legislation, but the Ontario provincial government has initiated consultation to strengthen provincial privacy protection. We don't know what that's going to look like down the road, but just something to keep in mind. So another note about PIPEDA on enforcement. PIPEDA is regulated by and enforced by the Office of the Privacy Commissioner of Canada. And the way, which we call the OPC for short, we like to use a lot of acronyms, and the way the Privacy Commissioner regulates and enforces PIPEDA, first, the OPC investigates complaints. Private individuals can make complaints to the Privacy Commissioner about an organization's privacy practices or lack thereof. And then the OPC can issue findings, which is kind of resembles a court case. It sets out the relevant facts. It goes into what the OPC might find deficient or might find appropriate about an organization's privacy practices, and then usually concludes with recommendations for what the organization needs to do or should do in the future to be better if the OPC found that the organization was deficient. And lastly, the OPC has the ability to enter into what we call compliance agreements with organizations, which means that an organization, if they realize somebody has made a complaint about them, they can contact the OPC directly and they can enter into a compliance agreement that can sometimes fairly often be private. And usually the organization will agree, sorry, we screwed up, we promised to do better, we're going to do these X, Y, and Z steps to improve our privacy practices, and then the OPC will be satisfied and won't necessarily publish a public report of findings. Under PIPEDA right now, there isn't a lot of ability for the OPC to levy fines or otherwise enforce the PIPEDA obligations, which is why, so you might recall that we talked about that reform happening under the statute. This is one of the main issues of enforcement right now. The OPC can make public an organization's bad privacy practices, but the OPC's hands are a little tied beyond that. And so, so we're expecting a lot of reform to introduce fines or fairly stringent fines like what we're seeing in California and the European Union right now. And very similar at the BC level. I feel like I'm repeating myself, but most of the stuff that's happening federally is also happening in BC. The Office of the Information Privacy and Privacy Commissioner BC can do very similar things. They will investigate complaints that somebody's made about an organization in BC. They issue these reports of findings, and then they publish guidance. And then there's one other enforcement mechanism, just something to keep in mind about, is private litigation. We're seeing an increase in tort claims and related civil litigation, especially class actions, for data breaches, for failure to keep appropriate protections over personal information held by an organization. They're still fairly infrequent, but they are increasing, and your damages and the damages for potential privacy breaches or other class actions related to privacy can be fairly significant. So this is just something else to keep in mind. Even if the privacy commissioners of Canada aren't going to give you a huge fine right now, you could be subject to private litigation if you've done something really egregious with personal information under your control. So we'll go over a couple other general principles just to make sure that we are we know what we're talking about when we're talking about these issues. And the most basic one is personal information. You probably have a pretty good idea of what personal information is. But under Canadian privacy legislation, personal information is defined as information about an identifiable individual, including information that can be used with other information to identify an individual. So the things that you would typically expect, and I'm sure you all know this: name, email address, contact information, race, nationality or ethnic origin, religion, age, marital status, medical history, employment history, educational history, financial information, DNA, identifying numbers like social insurance numbers, all of these things. And the other important thing to keep in mind with this principle is that information that can be used, information can be combined with other information to identify you. So things like a postal code that on its own is too vague, you wouldn't be able to tie a postal code to a single person. But if you used a postal code in connection with a name or in connection with an email address, chances are you might be able to combine that together and use it to identify someone. So personal information can be a lot more broad than just the information you typically expect. And some other things to keep in mind, personal information is information about any individual. So it can include employees, which is employees, customers, potential customers, and all of their respective employees, investors. It's very broad. Most people usually think of personal information as just being about their customers, but it's a lot more broad than that. But there is one carve out from personal information legislation in Canada, and that is for business contact information. So all these privacy law obligations that we're going to talk about, that doesn't apply to business contact information, which is the business contact information of an individual that an organization collects, uses, or discloses solely for the purposes of communicating with the individual in connection with their employment, business, or profession. That would be things like a work email address doesn't apply. And you can see the public policy rationale behind that. To be able to facilitate business, you don't want to have to impose all of these obligations around getting consent to somebody's work email address. And then, the theme of the day is that everything at the federal level is usually mirrored at the provincial level. There's a very similar exclusion for business contact information in the BC PIPA as well. So Canadian privacy laws are based on what we call a model code for the protection of personal information. And those are, and there are 10 basic principles in this model code. The 10 basic principles are accountability. You have to be accountable for the personal information under your control. Identifying purposes, you have to tell people what you're doing with it. Consent, you have to get consent, express or implied. We'll talk more about that. Limiting collection, don't collect too much. Limiting use, disclosure, and retention, don't use it or disclose it for any more than you have to. Don't hang on to it for any longer than you have to. Don't hang on to it in perpetuity unless you have an actual reason to do that. Accuracy, you have to take steps to make sure it's accurate. Safeguards, got to protect it. Openness, you need to be transparent about what you're doing with it. Individual access, under each legislation, there are rights that allow individuals to request access to their personal information that you hold. And challenging compliance, that's the one that gives individuals the right to challenge whether you as an organization are compliant with Canadian privacy law obligations. Just one thing to note about this model code, it is expressly codified in PIPEDA. And so PIPEDA actually sets out a bunch of privacy law obligations and then has a Schedule 1 at the end, which describes all of these 10 principles expressly. At the provincial level, the BC PIPA and the other provincial legislation doesn't do that, but the model code and the principles in the model code are implied in the statute. So very, very similar in practice, but in PIPEDA, you're going to have all of these 10 things set out in a very nice little list. So we're only going to talk about two of these model code principles today. The two most important are accountability and consent. And the accountability principle, it imposes responsibility on an organization for personal information under its control. The accountability principle requires an enterprise-wide, multifaceted approach, which means it's not just management, it's not just IT, everyone has to be on board, everyone is responsible. And the Privacy Commissioner of Canada has issued some reports of findings and guidance setting out what being accountable means. And a couple of them I'm just reproducing here for you. The Privacy Commissioner of Canada has said being accountable means you have to know your privacy obligations. You have to know what you need to do. It's not good enough to say, oh, we didn't realize, you got to know. The OPC, the Privacy Commissioner of Canada, has also said you need to develop and maintain a privacy management program, which includes oversight, it includes training. So you need to have somebody, most people appoint a person responsible for privacy, and you got to train your employees. So you got to have a program for how we're going to keep personal information safe. The Privacy Commissioner has also said you need to implement policies and procedures. You need to, at a bare minimum, you need to have a privacy policy, but you should be doing risk assessments, you should be doing employee training, breach and incident management response. What happens if you suffer a data breach? You should have a response plan in place. You need to have service provider management, which we will talk more about, and you got to keep revisiting these policies and procedures and make sure they still make sense for you. The Privacy Commissioner of Canada has also said if you try to argue that the industry standard, you were following an industry standard, but you still were deficient of your privacy obligations, not good enough. They don't really care about industry standards. You need to meet your privacy law obligations. And practical necessity, you just didn't have the resources to comply, again, not good enough. So that was the summary of all the relevant Canadian privacy law principles. And then now we're going to go into organizational privacy law obligations for outsourcing. A little bit about outsourcing explained. I'm sure most of you have a pretty good sense of what it is and are probably relying on it quite frequently. But basically, outsourcing is an arrangement by which an organization engages a third-party service provider to perform a business activity, function, or process. Examples, and many of these I'm sure are very familiar to you, IT system management, document processing, application processing, policy administration, marketing, research, back-end office management, HR services, and cloud services and cloud computing. Fairly often, the use of outsourcing includes the transfer of personal information across provincial or international borders to service providers. Service providers are located anywhere, and chances are the service provider that you'd like to use isn't happily located in your exact jurisdiction. And so fairly often, you will find yourself transferring personal information across borders to wherever that service provider is located, or to wherever that service provider has servers. Not always the same thing. Sometimes you could use a service provider who has their head office in BC, but they actually keep their servers in India. So these are good things to keep in mind. You might recall the accountability principle. So the accountability principle that we just talked about, it requires organizations to take responsibility for personal information protection. The accountability principle kicks in for outsourcing because an organization is still responsible for personal information that gets transferred to a third-party service provider. This is really, really key, and this is why looking at outsourcing is so critical for you as the organizations, because when you transfer personal information over to that third-party service provider and they do something with it, you're responsible. You need to do the due diligence. You're responsible for something they do. It doesn't necessarily maybe seem fair, but you made that decision to transfer that personal information across to them, and whatever they're doing with it, that's your responsibility. This is very, very key. Under PIPEDA, the model code that we talked about set out in Schedule 1 to PIPEDA says very expressly, an organization is responsible for personal information in its possession or custody, including information that has been transferred to a third party for processing. The organization shall use contractual or other means to provide a comparable level of protection while the information is being processed by a third party. So what does that mean? The Office of the Privacy Commissioner of Canada has happily issued a little bit of guidance in some of its previous report of findings and some of its guidance. And it said, you can satisfy your obligations under that clause 4.1.3 that we just read by implementing a contract with your service provider that contains confidentiality and security of personal information obligations, minimum information security safeguards requirements on the service provider. The contract contains specific rules, regulations, and standards to which the service provider must comply. The contract sets out roles and responsibilities of key stakeholders that handle personal information. The contract contains requirements around the acceptable uses of the personal information while the service provider has it. The contract sets out retention and destruction obligations, and the contract enables you as the organization to have oversight, monitoring, and auditing of what exactly that third-party service provider is doing. The Office of the Privacy Commissioner has also said the accountability clause 4.1.3 is not satisfied if you're unable to confirm what happens to personal information while your third-party service provider has it. Even if you have a contract, if you have no idea what they're doing, where they're doing it, that's not sufficient for accountability. And the OPC has also said a contract might not be required in some limited situations, but those situations are extremely narrow, unlikely to come up for you, and we would always recommend you have a contract. Those situations, just in case you're curious, is the OPC said you might not need a contract if you're transferring, if your service provider happens to be a close affiliate of yours, a parent company maybe, and the transfer of personal information is very limited in scope, and the personal information that gets transferred is not that sensitive. Again, very, very narrow circumstances. The OPC wasn't totally certain on this. We would recommend put a contract in place. So a little note on cross-border transfers for processing. This area, and so what I mean by cross-border transfers is when you transfer personal information across a provincial or international border. This position has been a little bit in turmoil over the past couple of years, especially last year. The OPC used to have a policy position through its guidance and investigations and reports of findings. And their old policy position used to be that transferring personal information across borders, they consider it a use of personal information, not a disclosure. And they consider additional consent is not required. So you do not need to go back to the person to whom the personal information relates and get their permission to use the service provider and to transfer that personal information to your service provider. Although they did say transparency is required, which in most cases means that you just pop something into your privacy policy saying, we use service providers located in other jurisdictions. Again, that was their old policy position. Most organizations, not a big deal to comply with this. In 2019, the OPC decided they'd give everyone a little bit of a scare. And in a report of findings, number 2019-001, the OPC said that actually we were wrong as a matter of law, and the transfer of personal information for processing is now what we would call a disclosure, not a use, which means that you need to go back to the people whose personal information you're about to transfer and get another consent to transfer that personal information across borders. You can imagine that this would cause a little bit of chaos. Obviously, that would be a little annoying in most circumstances, and might just be unworkable to go back to every single person whose personal information you have and you're about to transfer to a service provider. That's a lot of consent, and tracking that consent administratively very, very challenging for a lot of organizations. Last summer, the OPC, after a little bit of an uproar, opened up a consultation. People submitted their responses. The OPC reframed the consultation. There's some opportunity for comment. And then happily in September 2019, the OPC concluded they were going to scrap this. Their old policy position applies. And then just to be really sure, and most organizations gave a big sigh of relief at this, in Pipetta Report of Findings 2020-001, the OPC, they're investigating a bank, and in their investigation of the bank, they ended up confirming that the old policy position applies. Why am I telling you this? If the old policy position applies, it's because personal information laws are still a little bit in flux. And so right now, you do not need to go back to the people whose personal information you're about to transfer and ask their consent to transfer. But just keep in mind, if you read something about this in the news, this might change again, especially because this is obviously an issue for the Privacy Commissioner of Canada, and which means that the Office of the Information Privacy Commissioner in BC is likely to follow whatever the Privacy Commissioner of Canada does. So just keep in mind right now, you don't need to get an additional consent, but that might change. And then just to follow up with the BC PIPA, because this applies to so many of you, the BC PIPA doesn't expressly reference outsourcing, but it does say an organization is responsible for personal information under its control, including personal information that is not in the custody of the organization, which has been taken to mean you're responsible if you transfer personal information to third-party service providers. So the theme of the presentation, what we're seeing, the federal requirements very, very closely mirror the provincial requirements in BC. And then lastly, we're going to follow up with some practical recommendations for outsourcing arrangements, because I know I gave you a lot of privacy law background and a lot of theoretical discussion about this, but what exactly do you have to do to protect yourselves? So at the outset, as a preliminary matter, do your due diligence. We talked about engaging in a risk assessment. If you're thinking about using a third-party service provider, you need to look at is it even appropriate to use a third-party service provider for what you need to do. In some cases, it might be out of necessity, you're not able to do it yourself. And then you look at the specific third-party service provider that you're proposing to use. Look at the types of personal information that will be transferred. Is that appropriate to be transferred? And assess the potential benefits versus the risks. As another matter of due diligence, you need to understand the service provider's privacy and security practices. So we'd recommend looking at the service provider's privacy policy in terms of service. That should give you a really good idea of what the service provider is going to do with your personal information, and the kinds of things that might be concerning to you. And you should confirm that the service provider has implemented appropriate policies and procedures of their own to protect personal information that you transfer to them. And another thing, you can do due diligence on the specific third-party service provider that you're proposing to use. So we would recommend doing a Google, consider the experience and ability of the third-party service provider to provide the service. Google them, see if any issues are up on the interwebs, look at their, see if you can find anything about their business reputation, what's their financial strength. If they go under, are you going to be left in the lurch, or are they financially pretty strong? And consider any past issues, complaints, litigation. This is a good way to know exactly who you're getting in bed with before you sign that contract. And this can give rise to issues that hopefully that then won't happen to you. And then as a last note on due diligence, we recommend considering where is the service provider located. If it's in your jurisdiction, great. It might be located in another province of Canada, another country. And if it is located in another country, maybe just turn your mind to what are the privacy laws in that country. In some countries might not be an issue because they have privacy laws that are stringent or more stringent than ours, but some might not. And so that's a good thing to keep in mind too. And then coming to the contract itself, I'm going to say some recommendations for things that should be included in the contract, but I also understand that sometimes you don't have the ability to negotiate with a third-party service provider who to include appropriate provisions in the contract. And in those cases, it's your responsibility to read through. So that would be something like Microsoft. Microsoft is probably not going to negotiate with you when you're using one of their services. And that's normal and that's fine. But in those cases, I would take a look at the draft contract and just make sure that it contains provisions that provide you with enough security, even if you don't have the ability to negotiate with them. So some of the contractual provisions that can be included, and these will depend how stringent these are. These will depend on the service that you're using, the personal information you're transferring, how the value of everything that's included in the deal. But these provisions can include a wide range of things. They should set out ownership of data. You need to tell them that you still own the data. Confidentiality, third-party service provider, don't tell anyone about it. Safeguards, you need to put third-party service provider, you need to protect the information. Permitted and prohibited uses, setting out what they can and cannot do with it. Subcontractors, can they subcontract for somebody else to then use and process the personal information, or can they not? Organizational control, who in that third-party service provider is responsible for the information? Who's controlling this? Audit rights, you want the ability to go in there and see exactly what they're doing with it. If you have concerns, you want the ability to go in there and see records. Reporting requirements, do you want them to be able to report back to you about what they're doing, maybe annually, maybe monthly, depending on the nature of the relationship and what they're doing with your personal information. Data breach reporting, notification, and record keeping. You want them to tell you if there's been a data breach, even a small one. You want to know right away so you can protect yourself. Retention, deletion, destruction requirements at the end of the relationship. You want to have measures in place that require them to securely destroy personal information. They can't hang on to it forever. Termination, do you want the ability to get out of the contractual relationship? If it's not working out, concerns start arising about what they're doing, can you get out of it? Or are you locked in for a long term, or it's expensive to get out? That's important too. And insurance, do they have cybersecurity insurance? Do you have cybersecurity insurance? What happens if something goes wrong? Are you insured? Maybe you put in provisions requiring them to be insured, especially if it's a smaller third-party service provider who may not have the financial means to fight litigation. And then risk allocation as between you and the service provider. This is always a point of contention in negotiations with my clients. But who's responsible for what, and who's going to indemnify who if something goes south? These are important things to consider. And I say this all with the caveat that all these provisions, this will depend on the exact nature of what you're doing. If the third-party service provider is performing a really critical function with a lot of personal information, you probably want all of these in here and you want a lot of detail about it. But maybe you don't need quite as much detail if it's a very discrete task, or the third-party service provider isn't going to have access to much information. And then ongoing monitoring. After you do your due diligence on the third-party service provider and you hopefully enter into a contract that you're happy with, your obligations don't end there. We recommend continuous monitoring of that third-party service provider and the relationship between you. And this could be just checking in, making sure that they're doing what they said they would do, monitoring for any issues that might be coming up. If the third-party service provider has terms and conditions, do they have the ability to change those terms and conditions, and have they changed them? That's something to keep in mind. And then just continually assessing changes to the third-party service provider relationship. Is it still working for you? Do you have any new concerns? Do you maybe need to start looking at a new service provider? All these things are pretty critical to mitigating your risks that might come up. And lastly, some other practical recommendations. There are some other things that you can do to mitigate your risks. Review and update your organizational privacy policy to reflect that you use service providers. This is especially important if you use service providers located in other jurisdictions, because you need to be transparent about that. So you need to make sure your privacy policy mentions that. Limit the service provider's access to personal information. If they only need certain HR information to do their business function, don't give them anything else. Make sure they can't access anything else. And on a related note, you should implement internal organizational procedures for how to share personal information with service providers to prevent accidentally giving them an information dump of all kinds of things they didn't need to know. Another one, consider if additional consent is required. This is where we talked about how privacy laws seemed like they were in flux last year. Just keep in mind that privacy laws might be changing and consent might be required in the future. It's not right now, so don't worry about it, but it might be in the future. Next one is implement and regularly update organizational incident management framework. So if you do suffer a data breach, or if your service provider suffers a data breach, which, as you recall, you would still be accountable for, you should have in place a data breach response plan. What do? Do you need to, let's implement this right away so we can mitigate this? Who do we need to report to? Who do we need to notify? All these things you should already have in a data breach response plan already to help be on top of data breaches if they come up. And lastly, like we already talked about, just monitor Canadian privacy law developments. Nothing right now, but we're expecting some things in the future, and it could change some of your privacy obligations. So that's just something to keep in the back of your mind. Okay, and that's the end of the presentation. Does anybody have any questions?
That was great, Catherine. So much to consider when we think about protection of data. I'm going to jump in and say, like you mentioned Microsoft as an example of one of those companies that you, like, there's really, you can't create your own contract with Microsoft. So in some of those providers, you're thinking of, they have OneDrive, where a lot of people are using that cloud storage. There's Google Docs, you know, all of those things. How do you work, or what can you do to protect yourself when you're using those services, as most small businesses are now, right? We're using a lot of SaaS or software as a service providers. What do we need to have to protect ourselves in case something happens with one of those organizations?
That's a great question. There are a lot of things that you can do. You can't fully ever mitigate your risks, unfortunately. Right. But a couple of comments about that. Somebody like Microsoft could gives organizations a little bit more security, knowing that they are a very, very large organization with a lot of resources and a lot of financial ability to protect personal information and have a lot of strong business reputation. So that's one thing, the benefit of using a big service provider that won't negotiate with you. At least they have their business reputation and security to be able to back them up. A couple other things, I would recommend looking through those terms and conditions instead of just signing them and assuming they're okay, and just see what they're doing to their personal information, and know is Microsoft transferring it to a server located in India. Then that's something that you need to put in your privacy policy. And a couple of other things for one of those very large service providers, I would keep good records of who you're using for what purpose. And to the extent, and just make sure you understand what you're using that large third-party service provider for, and just keeping it to exactly that business function. If you only need to use them for a certain kind of personal information, then try not to dump everything up into the cloud if you don't need to. Okay.
And what about some of this might just be the same answer, but QuickBooks Online, accounting software online, where you are doing that invoice and billing, most of that is, I'm going to call it business information, right? Like if you're doing a business to business environment, but if it is business to consumer, Shopify is another one, right? A lot of people are using that for their online sales. So you have client information in there. And just as a note, I have a client that uses Shopify. We use QuickBooks Online, and I looked at making that process easier. How can we just take that data and transfer it over to record her sales? And there was a third-party provider, but when I went into their privacy and their terms and conditions, it basically was like, we're going to take that information and we can share it for research purposes with all of their subsidiary companies. that who knows where they are. So that was a pause for me. And I'm like, no, we're not going to use that provider. So how do you keep on top of that? Because again, if you're using multiple platforms as a small business owner, how do we manage using all of those services? What should we have in our own privacy policy that lets our clients know what we're doing, and that we take it seriously, but we are using these third parties?
Yeah, that's another great question and fairly similar answer. But for a privacy policy, the basic purpose of a privacy policy is to explain the ways you collect, use, and disclose information. So if you're using third-party service providers with servers located in India and who may transfer personal information for research purposes, you have to put that in your privacy policy. You need to be transparent to your customers. And then another thing, like you said, Carrie Lee, that was excellent due diligence to realize that prospective service provider was sharing personal information with its affiliates for research purposes. And that's something that you might not be okay with, and then you don't use that service provider. And like that is something that's a purpose, or that's a use of personal information that your customers certainly wouldn't expect, and in a lot of cases probably wouldn't consent to. And so then you need to find a new service provider. That's why the due diligence at the beginning is so important. Pull up their terms and conditions and their privacy policy and make sure you understand what they're doing and that they don't have anything egregious in there.
That's right. There's another question from Jacqueline coming in here, Catherine, if you want to take a look in the chat.
Yep, I'm looking at it right now.
Perfect. So I'll read it out here. It's, can we hire someone like yourself to help us create a privacy policy to put on the website, where you can help us go through the third parties we are using to see if they are compliant with our needs for privacy?
One of the things we do is we absolutely do draft privacy policies for our clients. If you would like to consider that, or you think your privacy policy might need an overhaul, feel free to contact me with the email that was set out at the beginning of this presentation. And on the third-party service provider point, we can help. We generally don't do due diligence on third-party service providers. It's just not probably the most economical use for you of a lawyer, but we definitely help with general advice and any specific questions that you might have. And for those third-party service providers, I would really recommend just starting out and looking at the terms of each service provider that you use and their privacy policies. And if you find anything that seems not quite right or seems a little weird, that's when you might be beneficial to engage a lawyer to check in and see if that's okay, or if that's going to give rise to some concerns for you and the personal information that you have about your customers.
Okay, good. And is it, like, an example would be if you're using, let's say, the Google Docs, right? So you're using the Google platform, you're using QuickBooks. Can you just name those organizations and then have a link to their privacy policy for to keep in your policy, so that, again, it's always updated and it's always quick if I, as your customer, want to research more? Is that a good way to also do that, so that everything is like hyperlinks I'm talking about, like on the website policy, so that you can see and click through as a consumer yourself?
You absolutely can do that. In some cases, you might even not have to go that far. You could say, these are we use third-party service providers, and give a brief overview of the kinds of service providers you use or the kinds of functions you use as examples, just so you don't need to name specific organizations, but just so people understand that you use back-end service providers, you use cloud computing, these are the things that you use.
Okay, that's good. That's probably easier for sure.
Yes.
Yeah.
Less updating.
Yeah. And then I just made a note here about the data breach response plan. What type of things should people consider, like maybe the top 3 things that they should have in there if they're going to implement something themselves?
Also a good question. Data breach response plans can be very complicated. The Office of the Privacy Commissioner of Canada has a good little overview on their website if anyone has any immediate concerns. But the most important things you want to set out in a data breach response plan is you want to know, I would set out who is responsible for responding to the data breach, so you're not scrambling trying to assemble a team. And I would set out some initial measures to collect information on exactly what happened. Some measures on how you can stop it right away, because you might not even know the extent of the disclosure or the unauthorized access, or whether it's still continuing. So you want to put in some measures on investigating the scope of the breach and whether it's concluded. And then I would put in some measures on, do you need to report or notify anybody about the breach? And this is why it gets so complicated very quickly, because there are some data breach obligations at the federal level, not in BC, but at the federal level, of if your data breach reaches a certain threshold of risk of harm, which again is a very complicated question. But there are some data breach reporting obligations, and then there are some obligations about notifying people or organizations that might be impacted. And so you need to know if you need to tell anybody about it.
Right. Okay, good. Our time is good. We're at the 1 hour. That's great. Thanks so much, Katherine. Okay. Again, we've had a couple questions that we've answered, hopefully. And if there's anything else, again, we'll share Katherine's information in the follow-up email. Just quickly, we have a couple other sessions coming up here in the next couple of weeks. So another one on how to get traffic to your website. So again, if we're getting that traffic and building our business, it's good to have our privacy policy updated on there as well. And then opportunities to bid on Government of Canada opportunities. And don't think your business is too small or there isn't an opportunity for you. There's lots available out there. So I encourage you to join that one as well. We have some internal programming coming up. So peer mentoring groups, taking the stage leadership mentoring, our financial fitness webinar series, and a build your business webinar series. So lots of training coming up here over the next couple of months. So again, thank you for joining us. Thank you so much, Katherine, for taking the time to provide information on privacy and outsourcing. Thank you to everyone for joining us, and enjoy your day.
Okay, thank you, Carolee.